We will now begin the second part of this public hearing, and we're going to discuss We're going to start a public hearing now. Okay, we're going to start the public hearing now, please. So, thank you. The first hearing, the first bill that we're going to discuss will be Bill number 139-33. It's an act to adopt the rules and regulations to govern the commercial leases and licenses for commercial use of Chamorro Land Trust properties, and to add new subsections 14 and 15 to section 6.9G, and to add a new subsection G to section 75-107 of Chapter 75, Title 21, Guam Code Annotated. Signing up to provide testimony on Bill 139 is Mr. Michael Borja. So please step forward, Mr. Borja.
Off day, Mr. Chairman, Vice Speaker Cruz, Senators. I'd like to also acknowledge the presence of two of my commissioners from the Chamorro Land Trust Commission, Mrs. Amanda Santos and Mr. Pascual Sablan, that are here with us today, as well as my Deputy Director from Land Management, Mr. Dave Camacho. I'm Mike Borja, the Director of Land Management. On Bill number 139-33, the Chamorro Land Trust Commission's Rules and Regulations for Commercial Use, transmitted to the legislature on June 3rd, had been a major undertaking for the last 3 years. The rules underwent its mandatory review process in accordance with the administrative adjudication law, beginning with its public hearing on November 20th, 2014, where both oral and written testimony were received, and I'm proud to say that they were very favorable. Suggestions from the testimonies were implemented, and the CLTC Board of Commissioners approved the final product on January 6, 2015. The document was immediately submitted to the Attorney General for review, and after an intensive review, it was approved on May 8, 2015, and forwarded to the Governor for transmittal to the legislature. Today we meet to embark on the formal process for the legislative approval of the rules that should have been created and adopted decades ago. The rules are necessary for the CLTC to engage in commercial activity of its lands for the purpose of creating revenue that would be used to enhance lands intended for residential and agricultural use. Our most pressing need is to install the basic forms of infrastructure on these lands, such as water and electricity, to enable the full realization of the land. I must also assure our supporters and land rights friends that the CLTC does not intend to arbitrarily convert land for commercial use for its sole pleasure of increasing our treasury. On the contrary, we intend to judiciously select properties for commercial use that most obviously fits that category. These would include lands that are on major roadways and those that are not suitable for residential or agricultural use due to its proximity to lands already zoned commercial or industrial. These rules would also allow CLTC to engage in development of residential subdivisions where we could partner with developers and contractors of all sizes to assist in the creation of neighborhoods with affordable homes for eligible applicants. We envision communities to be constructed with a full entree of infrastructure such as roads, sewer, water, electricity, and telecommunications. These rules will help CLTC move to a new level where the leasing of raw land at the enormous cost of installing water and power would not have to fall on the residential or agricultural lessee, but be funded through revenue from commercial leases. As our island grows, so must we. However, we need to be prudent with the use of our land and to ensure it is sustainable and that we assure land will still be available for generations to come. The trust we have been entrusted with is a serious responsibility, and the CLTC, along with the Board of Commissioners, stand ready to protect it from misuse. With regular financial audits now underway and 3 of them completed in just this last year, our tasking must uphold our objectives. The scrutiny of our commercial activities will be an integral part of these audits, and we have been ramping up our financial controls over the last year to uphold this responsibility. On this note, we must also note that the increased revenue from commercial leases would assist the COTC to add more personnel to perform duties such as property management, compliance, and enforcement of all our properties. The COTC manages a significant portion of this government's land with asset values in the hundreds of millions of dollars, which plays a significant role in our government's financials. Additionally, the controls over the lands have been insufficient, and as a result, misuse and neglect is not unusual. These rules will provide the COTC with the revenue it will need to undertake these necessary responsibilities to safeguard all our lands and manage them to the highest standards. I and the COTC Board of Commissioners strongly recommend the legislature to pass Bill number 139-33 to allow the Chamorro Land Trust Commission to fulfill its mandates as our leaders from generations past had envisioned. I thank you for the opportunity to testify on this very important legislation.
Thank you, Mr. Borja. Also signing up to provide oral testimony is Mr. Joe Garrido. Go ahead and step forward, please. Mr. Borja, maybe if you just stand fast there, and after the oral testimonies are given, we'll open it up for questions.
Good afternoon, Senators and Chairman Tom.
Good afternoon.
I haven't really digested the bill being heard, but I'd like to make a comment. The comment with regards to leasing of properties to create revenues to develop both infrastructure for the agricultural and residential leases for the Chamorro people to establish their desire to have a home and to have a ranch. I think I forgot that the protocol. My name is Jose Ulloa Garrido, and I'm from Dededo. I know already that this thing, the issue, have been going on for 20 years, maybe. And at the rate that we are producing revenues to plan to develop the infrastructure for the Chamorro Land Trust properties, we might be able to achieve that in 50 years, 100 years. I'm trying to not to be sarcastic, but at the rate that we're going, and at the rate that the Chamorro Land Trust has been taken piecemeal for projects, for housing developments, I don't think we're going to have much property to develop for the Chamorro people. My proposal is to borrow money, borrow the amount that the intelligent developer planners might come up in order to achieve the infrastructure development and use the leases to pay the installment plans. I have no idea how much money it would take to develop infrastructures. Maybe we're talking $20 to $50 million. But why can't we do it the way we do it the other way? When agencies need money, they just go to the bond market. Or maybe that's not even a good way, because they might just take all the land, because if we don't pay it, we go broke. What we need is a definite plan to create the revenues by borrowing and using the lease the commercial leases to pay for the installment plans. I don't know how viable that is, but it's been a long time in coming, and since the 1975 we have been tackling this issue, and I'm beginning to realize that before all these things are done, when we're gonna all pass away, and somebody else will be tackling the same thing. This issue is like the war reparation, and that's just my recommendation, is to try to get together and think whether that's a viable idea, so that we can have Chamorros who don't have properties, who don't have homes, realize these intended Chamorro dream, if I may. There might be something here that I might not necessarily agree upon, but at this time I don't have the time to read all of it yet. But I know he had done a pretty good job. I'll bet burning a lot of candles. But that's all I can say is that's the proposal I have. And let's concentrate also equally on leasing the property to the Chamorro people, and not just thinking about commercial leases and all that. I do know for past experience that Chamorro Land Trust seems to be a land bank for Gura projects, and there are some properties that were taken from our lands to create housing for everybody in the world except us. Thank you.
Thank you very much, Mr. Garrido. Does anybody on the panel have questions regarding Bill 139 and the testimony that's been given? Yes, Senator Rogers.
Thank you, Mr. Chairman. I guess that the nature of, you're not hearing any concerns coming from committee members at this point in time, but looking at the rules and regs, I know the chair has 90 days to be able to act on this, otherwise it automatically becomes effective. Now, are there any issues that since the submission to this legislative body that you would like to bring to our attention that perhaps you would recommend, following your individual discussions with senators, that you would recommend the committee consider making slight adjustments?
None at this time, and part of this bill did incorporate two different amendments, one for the law and one for the rules, that the Attorney General had to have a strikeout because it was not sustained by the law, and so we had to amend the law in order to add the sections that deal with subleasing and assignment. But no bill and no law is perfect, so I believe over time we need to, if there's needs for modification, we'll definitely be coming before this body to seek those modifications that might be necessary.
Okay. Thank you, Mr. Boyer. Thank you, Mr. Chair.
Thank you. Anyone else? Speaker?
Thank you very much, Mr. Chairman. Can you, I've been hearing a lot of talks about there in terms of the commercial leases. Can you clarify for me exactly who can apply for a commercial lease? I mean, at one time I heard that you definitely have to be, of course, Chamorro blood. The other is that you have to have a partner. As long as one of them is Chamorro, you can have partners from anywhere else. And then the third I heard is that it could just be anybody, Chamorro or not. Can you please clarify then because we know for residential and agricultural who can, but for commercial leases, I was reading here as fast as I could to see if I could find it.
In the Section 6(9)D eligibility, it discusses that specifically. And anyone that has a corporation, whether they're a sole ownership, sole proprietorship, or a partnership or a corporation, is eligible so long as they're doing business here on Guam, they're licensed to do business here on Guam. Now, the part where we did also include is that there would be preferences to those who did have someone who meets the eligibility of a Chamorro, whether it's one of the owners or a member of the board.
So is there something very similar to maybe eligibility for employment where they get preferential points? Would that be the same as well?
Right.
Here?
I mean, we haven't devised how, when it's going to be looked at, but if it's a tiebreaker, it would be the organization that most likely has either someone who meets the Chamorro eligibility rules that's spelled out in these rules.
And how long are these leases for?
Well, current law says that, I must go, they have to be for 5 years.
5 years.
But, of course, if it's going to be something that's going to be long-term or they're going to be investing significant amounts of money in the investment for building something on that piece of property, we will definitely be coming to this body to be seeking out additional time using a determination of need and requesting what we believe would be the most appropriate amount of time, knowing that the maximum is 50 years plus 49-year option to extend.
And the rules does not speak to that? I mean, you're still
No, ma'am,
adhering
because
to the 5 years?
Right. I mean, the rules are superseded by the law, so we have to try and keep these rules as general so that they can work wherever it goes, so that they don't come into conflict with the law at some point. So it's whatever the prevailing law of the time is.
So would it be then, in your thinking, that should there be a need then to go beyond the 5 years, that you want to come and do it, a blanket request to not stick to the 5 years, or it would be a case by case? So as an applicant, a commercial, applicant come to you and they want more than 5 years, are you going to treat it and come to the legislature with that one applicant at a time?
Well, as my preference is that we had no limitation, except for whatever, we don't have that 5-year limitation. It can be a case-by-case basis, it can be in general, but just know that if I'm going to be putting out something for a commercial purpose, if there's an intention by potential investors to invest a significant amount of money, we will be asking for something greater than 5 years. And yes, I would like to have something that's blanket where we don't have to do that. But just know that these rules do have specific guidelines for us to follow, and especially for the corporations and whoever has this commercial lease, there will be financial responsibilities on their part. The audit, our annual audit's definitely going to be, this is going to be a major focus to make sure that it's managed and properly accounted for. We already have some of those kinds of write-ups that we're working through from the audits we've had from these past, just the 3 audits we've had in the last year, one that just came out on last Friday. And we haven't been able to react to most of them instantly, although we have been working on them because, 3 audits over a period of 4 or 5 years, covering 4 or 5 year period, to have 3 separate audits in 1 year is pretty fast tracking our audits. And but we've been responding to each and every one of them as we moved along. But it's been unfortunately a very slow process. You might have seen in Friday and today's newspapers too. We've had to put out a notice to contact people who we've had a difficult time in getting a hold of, and this had to do with the Chamorro Home Loan Guarantee Program. And here we were, the auditor definitely was on our case to get down to the bottom of that, and we've been working at it very hard. That list you saw in the paper was just the group that we have not been able to make any contact with, and we've been pretty successful. That advertisement on Friday brought in quite a few people to clear up their, give us the information we've needed.
Do you have designated certain areas on the island that will be available for commercial leases?
Well, like I mentioned before, those along the roadways most especially, where there's already some kind of potential commercial activity that's going to occur, anything that's going to be someplace where it's not suitable for agriculture or residential at all. And there may be some other areas, but some of the things that people have already expressed interest in, I mean, they're out where there's M1 zoned areas, even though it's in the middle of nowhere. They've expressed some interest. We've just been holding back. We told them, submit your request in writing. Once this is approved, then we can entertain it. But when we entertain it, it's not to say here's your land. It's going to be a solicitation process, as we've stated in these rules, that will open it up to everyone that's interested in the process, and they go through a solicitation process, and it is reviewed by an external group.
Well, so we all know, of course, that there's just limited amount of land available in such a small island, and the list of Chamorros, so those who are on the wait list right now to apply for residential or commercial lands have not even been, residential or agriculture have not yet been fully met. Would then these areas that you're going to designate as commercial, then in essence deprive those Chamorros on the wait list from ever having a piece of property, for themselves and for their children in the future?
No, we don't believe so, and that's the children in the future is who we want to also make sure we're holding back land for, not just our grandchildren and great-grandchildren, but even beyond. In the exercise of doing the tax assessment that the Rev and Tax did in the 2014, we at Chamorro Land Trust had to go through that exercise in a major way. It's still underway. In that process, we went out and accounted for all our properties where there were already some homes existing and many other places, and we did major subdivision drawings, and that's all in the review process for approval. And so those lands we definitely know will be at some time now or in the future potential for community development for residential use. We see that the commercial rules and regs will help us to advance that exercise of creating more homes for residential use. As Mr. Garrido had mentioned, we believe that they will be able to do this in ways other than having to go out and seek out money to do it by having developers develop it for us. They'll get the money out of selling the homes, but they'll be building the infrastructure in the meantime. There may be some need to put some other boost into it, but we couldn't enter into those kinds of agreements with developers and contractors without these rules in place. And so that's why it's important for these rules to be in place as well. Even though we're not going to be expending money for some of these developments, we believe we still had to have these rules in place so that we can entertain commercial activity such as that.
Do you have I know you said those that are like along the roadways are examples of lands that can be used for commercial. Of all the lands that have been set aside, for residential, agricultural, commercial, but then at the same time, of course, we have land set aside for future expansion of departments and agencies, reserved for departments and agencies. And then you have the legislature who's always then taking land out of the inventory to use for either compensation, land exchanges. And I'm just wondering is that, we're not talking to each other. I don't think we are. Where we don't see the master plan of everything, of all the lands that are available. Then you don't see what the legislature is doing maybe until maybe after the law's passed, or if you provide testimonies of land transfers, exchanges, giveaways, or whatever there are, for just about anything really, that we're slowly, of course, depleting the inventory. And that's why the concern that I'm hearing from Mr. Garrido is that then in the future, there may not be available lands then, because every day we're seeing it being depleted. And I know that what you're trying to do with the monies to be generated for these commercial leases was to be able to try to go in there and help, of course, develop and put the infrastructure in there for those who are, for residencies. And then for other things, of course, to manage the whole real property by TLTC, I'm just wondering whether a time will come then eventually where there's just not that forethought of planning really for the future. We're always acting on today, what's happening today, but never really for the future, and that concerns me. And just like when you mentioned, of course, the legislature decided that 5 years was going to be the maximum number of years for leases, so that we don't find ourselves, further down the line that we'll eventually never even have access to those properties. And I'm just wondering about the different types of activities as well, leases that's going to take place where either the land would not be suitable anymore for even residential or commercial, residential or agricultural, depending on what type of commercial leases, you're going to be giving out. And I don't know, also the other thing is, I don't know whether you have described exactly what type of commercial leases you're going to allow. Is there a limit to that, and what anyone can do to the land itself? And I hope, of course, not to destroy or contaminate, that it would never be available for anyone to use, for humans or animals, for that matter. So, and I apologize, of course, I've not read the whole thing, and I will. Just want to make sure, though, that, we do always try to protect these lands, for future generations. And once you meet that threshold, of course, of how much you're going to need, and I hear Mr. Garrido, too, saying that maybe the need should be, rather the move should be towards borrowing to go and put in all the infrastructure versus the monies that we're going to be getting from the leases, and that could take some time. I'm just, wondering really how quickly are we going to be able to accomplish what it is that, we're hoping to do with commercial leases.
Well, getting back to some of the questions, some of the things you mentioned, we hope to have for you an actual graphic pictorial of Guam that will show you where all the where all the CLTC lands are, and it'll be quite interesting to see, because you'll be able to see it's the zoning map, and it's also the tax zone map that was created for this tax assessment, and it really sticks out very clearly what's government lands and what's shown there. Now, like I mentioned before, what we hope to do with the development is to not have to put too much money of our own into it, or even any money, and that it becomes the job of the developers to make their money off of selling the homes that they're going to build there. And on these residential lots that we're building, these subdivisions that we're going to build, we can actually get down to something that's much smaller than the half-acre lot size that's usually allotted for a residential lot. We can get down to the sizes that accommodate a home and fit more homes into it, so you can get more, it costs less to put the infrastructure per house lot. And that's what we're hoping to envision. The rules also state that we have to be very careful about the environmental protection of the land. We ask that that they're required to do an assessment of the land before they take it, so we know what the starting point is, and then whenever the lease expires, that they also again do another assessment to determine what condition the land is, so that if there was any kind of spoilage of the land, that they'd be required to take care of that when they leave. We're also specifically state in the rules too that we want to protect any kind of historical sites. If any sites come up as having historical value, then we need to make sure that that's noted, and we act accordingly.
Did I hear you correctly when you're saying that if a developer was to go in and develop the lands, build these homes, and then turn around and sell them, who are they going to be selling those?
They're going to be selling it
houses
only
to?
to the qualified applicants that meet the Chamorro Land Trust rules.
Okay.
The people have already signed up. We're going to go through that list and hopefully not have to jump. We'll be going through and asking people if they're interested in these subdivisions to also get some assistance for them to qualify for loans. Now we're looking at building affordable homes here, so that the cost of the infrastructure plus the cost of the home should be somewhere around $100,000 in that neighborhood. And that's not too bad if it's, maybe there's some could be smaller, some could be more. But right now, we think that the cheapest price that we can see for a full infrastructure in a subdivision development is roughly around $25,000. But if a person tried to put in the water and the power into their house, they're being told they got to put in a 6-inch water line, which could cost thousands of dollars, plus pay for any of the power poles that require for their electrical hookup at $5,000 a pole. So you're now talking quite a bit of money. We had a constituent who came in to ask to swap her land because it was going to cost her $80,000 to hook up the 6-inch water line to her lot and $25,000 to install 5 power poles. That was way more money than she could even envision paying, and she hadn't even started to build her home. So we're trying to get away from that kind of stuff completely. But nothing can ever be for free. I mean, if the infrastructure can all be there along with the cost of the home, just like buying another subdivision home in someplace else on the island, I mean, it's well worth the price at $25,000 to get the road, the power, the water, the sewer, and the telecommunications.
Okay, Senator? All right. I'd just like to, first of all, maybe say a couple of points. First of all, what this rules and regulations does. Right now, the Chamorro Land Trust law, which is Chapter 75 of
Title 21.
Title 21. It's very clear in Section 75-107F. It says, nothing herein, this is in the law, nothing herein shall be construed to authorize the commercial lease or the license of Chamorro Land Trust properties prior to the promulgation of rules and regulations. And so with Bill 139 then, it satisfies that, or it does away with that restriction, and now will untie the Chamorro Land Trust Commission's hands to be able to then issue leases. But now for commercial leases, I think it's reasonable to assume that your investors are going to invest money that's probably going to require a lease that's going to go for longer than 5 years.
Correct. And
the law then that requires that any leases beyond 5 years have to come down to the legislature for legislative approval. So that is also applicable to Chamorro Land Trust properties. Is that correct?
Correct. And so before we would even entertain pieces of land, then we would go through that process to begin to ask for the extension or ask for a period of time that would be greater than 5 years.
Right. And so the reason why what I'm leading up to is that we know that there's a lot of interest that have been shown for commercial leases on Chamorro Land Trust properties, and some have even suggested lessee work out basically that lease and then come to the legislature for approval of those leases if it is beyond the 5 years. Is that correct?
Correct, but we would want to come in if we have an idea of what we're going to use the land for, and we need to have 50 years. We're going to come and ask for the 50 years so we can begin the discussions or even get someone to lease the land, because some of them may not even be interested in leasing the land if there's a limitation of 5 years. And then when we're concluding when we've concluded the lease, then that lease contract, then we come back to you for the approval.
Yeah, but I think the way the law is written right now is that if you foresee the leasing out of commercial property for longer than a period of 5 years, then I think the law requires, I guess in this case, the governor, or no, I guess it'll be the Chamorro Land Trust Commission is going to have to issue a notice of determination of need.
Correct.
Which basically says, world, we've got this piece of Chamorro Land Trust property that's going to be available for development. And then that is supposed to be a notice, that's supposed to be a notice that that property is available. The legislature does not have to approve that determination of need. A copy is given to the legislature just for information.
Okay.
So the legislature really does not get involved until you have developed a lease, and then it comes down to the legislature, and the legislature either approves it in whole or disapproves it. Okay, can't go in there and tinker and say, well, we don't like provision 1 or 2. Is that your understanding?
That's my understanding, and as I spoke to many of you individually the last month concerning these rules, it would be in our interest too to work with each and every one of you as we're progressing through this lease to make sure that there are not going to be any showstoppers that will that we can encounter.
And I want to commend you for it. You know, you've really done an excellent job of reaching out and touching bases and saying, look, here's what we're doing. This is what we may need and all that stuff. So I certainly applaud you for that. I got one last item, and that is on the on section 6.9G of the rules and regulations, and it has to do with the terms and conditions of the lease agreements, lease or license. And it talks about, first of all, the rent shall be based upon fair market value. And secondly, the fair market annual rent shall be no less than 9% of whatever that value is. And that the rent shall escalate at 5-year intervals based upon original appraisals, whatever. But it shall be no lower than the rent charged during the previous 5 years. But there seems to be a gap there. It says you have to increase the rent every 5 years. And it cannot be lower than what it was previously, but it doesn't say. So does it sound reasonable that if a rent is increased by 1/2 of 1% after 5 years, does that sound reasonable?
Any increase is reasonable, but that would sound reasonable. I mean, the intent here was also to have some flexibility in the negotiations with whoever we were going to have a lease with, but yes, that would sound reasonable.
So it seems that maybe for that particular provision, we may need to put maybe some kind of language that, you know, I mean, reasonably, just the rate of inflation alone, probably the escalation should be no less than a certain percentage, and that is something we're going to need to look at closely.
Right.
Okay. Does anybody else have any questions? Senator Barnes?
Mr. Chair, maybe just for clarification to Mr. Bora, and just based on the earlier discussions that you answered from the speaker, I just want to make sure. I know that before the rules and regs were done, I was under the understanding that there were some leases or contracts that were probably still pending, or the board of directors had approved pending the rules and regs of this commercial leasing. Are there still any out there? I mean, just excuse my naivety, because you said something that you've made vigilant effort, and that may just be for the housing or some other smaller program, but are there any existing contracts out there that was signed? Maybe because I know that it took a long time for the rules and regs in this AAA process to go through. But if I'm not mistaken, I know that at one point in time there was an attempt to come to this body to approve a certain contract or certain lease as it relates to commercial leasing. And I just wanted to ask that question if I missed it by any chance.
Yes, there are some commercial leases that already exist. Most of them, however, were already permitted by law, things like telecommunications and stuff like that. But the golf course was also one that preceded the Chamorro Land Trust, so it was also written into the original law to allow for the municipal golf course. But there are a couple of them that are out there that are currently underway that we just have to live with because the law requires us to still grandfather them, even though they didn't fall under these rules. But that every effort should be made once that lease expires or comes to term, that we should then institute these new rules in place. We did have to put one project on hold. It was really not a lease. It was not a license. It was a mineral extraction program to fix some land up for future subdivision development, and that the Chamorro Land Trust would receive money from it. But our attorney said if it smelled like a lease and looked like a lease and acted like a lease, it was a lease. So there's no rules, so you can't do this. And so we had to put the emergency stop on that one, and we're just waiting to kickstart it back up again once these rules are done. And that company is standing fast and ready to get going again too.
Thank you. Mr. Chair, I truly appreciate the answer because it has come to our attention again, and we just wanted to make sure that we are aware of it, and then hopefully we can collaborate our efforts once the rules and regs are in place because they've come to us.
Okay.
Thank you.
Anybody else? Senator Torres?
Mr. Borja, with regard to commercial leases, the authority to approve commercial leases is strictly with the board, the CLTC board, is that correct?
The final authority to approve the leases is with the legislature.
With the legislature. And the input of the public with regard to leases, is that afforded them at the CLTC level or at the legislative level? In other words, if I were a resident and I had an opposition, what degree do what is the venue for residents to express their disapproval if there is a commercial lease that's being entertained?
Well, it could be at the Chamorro Land Trust Commission meetings. There will be public announcements when we are looking to lease properties, and we'll specifically state that. We'll have a solicitation offer, so it will be an opportunity for even residents in the area to make note of that. If they have objections, they can bring that to the board meeting when we begin the discussions on that. But it's the Municipal Planning Council for the mayor usually doesn't come into play until if there's going to be any kind of zone change or anything like that. But it's something we can entertain. It's not something that we had thought about, but it is something that can be entertained, and we can add on to it.
I would as a citizen, I would think that that's important, though, to have that component where the public is well aware and has the opportunity to voice their concerns in favor or against, should there be, because we understand that Guam's areas those developed areas are in proximity to most residences, and I think that residences ought to have not only full knowledge but an active role in voicing their concerns.
And that's that was the whole intent of this purpose too, is to make sure that there was full transparency to everybody, that it's not some good sweetheart deal for somebody. I mean, it's intended to be completely open.
I
Yes,
appreciate
we can work on
that. Yeah, because that is of concern to many. Thank you.
Senator Blas?
Thank you, Mr. Chair, and thank you, Mr. Borja. With regards to the determination as to the commercial leases and what kind of activities are going to be permitted, how does that process start?
Well, it also depends on whatever the zoning is. But let's say we have a piece of property that is zoned agricultural, and we intend to use it for something commercial, or even in an area that might be suitable for light industrial. Then we would work on rezoning the property before we open it up, so we can have the best use of that property. Now, like I said, we've had some people who have made offers to want to use certain lands. We've told them already that we'll take your consideration into account and hold on until these rules are adopted, but that they would then have to answer a solicitation along with anybody else that might be interested in using that land, and that we can't reserve that land strictly for them.
So theoretically, if somebody wanted to lease a piece of property for commercial use and wanted to put up an ice factory, ice making factory, the legitimate ice. Okay. Then what you would do is the commission then would then put out a solicitation and say, look, there's interest in this piece of property for the purposes of doing this type of activity. Is that how this
It doesn't necessarily, no, we don't have to specify what kind of activity it is, but we're going to be opening up that piece of property, and we're going to be looking to see whatever's the best and highest use of that property that's going to get us the most value for it, and then also looking to see that it fits whatever the needs are in that community, or it doesn't object to any of the other needs. Now, if it's a factory and it's in the middle of some place that, the winds are going to blow right down into, a major village, and obviously it's probably not going to be something we might want to do. But it's, again, that kind of stuff is going to all be looked at. Everyone's going to have the opportunity to solicit something. It's going to be weighed out and evaluated by a team that's not Chamorro Land Trust, and they'll be able to help us out in picking whoever the best offer was.
Okay, so but the determination as to what kind of activity would be the best use for that piece of property, who would make that determination? The commission?
Well, the commission, one of the commissioners will make up that group.
Okay.
But the Chamorro Land Trust has a memorandum of agreement with the Guam Economic Development Authority to manage our commercial properties at this time.
Okay.
And they would be the ones that would help us and assist us in seeking out people to lease the lands. We are not in the business of trying to find people to lease the properties.
And
we don't
that's
have that
probably
expertise.
where I was getting at is then
Right.
I was a little bit concerned as to getting into that portion.
No, we're not
Okay.
experts in that, and so that's why we partnered up with Gita to help us in that side of the house.
Okay, and that's somehow inferred or within the rules and regulations or within the procedures and policies?
But I mean, it's in our an agreement already we have with them.
Okay.
Should that agreement expire and we decide at one point in time that we might want to do it ourselves, or even solicit that process out to find someone else that wants to manage it, and help us in that respect, then that might be the case. But right now we have an agreement with Gita.
Okay, appreciate it. Thanks.
Does Chamorro Land Trust have a standing list of prospective commercial tenants that have expressed an interest?
We have a couple of them. Because everyone that's come to us recently, we've had to tell them that there's no vacancy because we couldn't entertain anything. The most recent group of people that came looking for land were people that were trying to answer a Guam Power Authority RFP for solar or alternative energy systems, solar power and wind energy.
But you don't have a quasi-firm list of...
No, I think I have one or two letters.
Back as far back as maybe 2010, there was like a list of about, I want to say 200?
No, we don't
200
have.
prospective tenants?
No, we don't have something like that.
No? Okay.
No, because we've been holding off on this for the last several years. We've been telling everyone nothing can be done until these are done, and so we weren't entertaining anything.
Okay. Let's assume that that this thing, the legislature goes into session last week of August. Let's say September 1st, the governor passes the bill and adopts the rules and regulations. Are we at a point right now where we've basically got the makings of a lease agreement with a prospective tenant? And then shortly after that, maybe by the end of the year, or?
Yes, there's that one I mentioned earlier that
Okay.
we did put on hold. That everything was done in accordance with the processes
Yes.
we already had in place, and it was all done through proper procurement processes. We just had to stop the execution of the contract until this lease has been done, and then we'll be introducing that for approval here.
So for that particular one, and this is an area on the back road to Anderson, basically, where they're going to do some mining, correct? They're going to
Mineral
mine
extraction. We're not going to be creating a big
mineral
hole.
extraction. Is that going to have to? Are you going to have to then begin with a process of issuing a determination of publishing a determination of need?
No, No, sir. In this specific case, we decided to stay at 5 years.
5 years?
Right.
Okay.
But this whole process will really begin only their formal part of their evaluation of the property, because they want to do their due diligence to determine whether or not there's viability in executing the remainder part of their contract.
Right. Now that's, so you're looking at issuing a 5-year contract, that's including any options to renew, 5 years total.
I can't recall if we had any options to renew. We may have had some options to renew, but they knew that it was just 5 years. Everything, all the calculations were based on 5 years.
Okay, because I believe that the authority of the department to lease property is limited up to 5 years, and that's inclusive of renewal options. So it could be a 3, 1 and 1, or a 4 and a 1.
They knew we had to come back again for another 5 years. There was, I have to take a look at it again. It's been a couple years since I read the lease, but I know we were sticking with just 5 years.
Right.
Because all the calculations for the financials were based on a 5-year contract.
I hope there's not a thought of issuing out a 5-year lease, let it expire, and then come back and...
No, we were going to work, we had already talked with them that if we wanted to go beyond that, we would be going through the appropriate processes to get it extended.
Okay, all right, fine. Does anybody else have any other questions? Mr. Sablon, I believe you had signed up last minute to provide oral testimony. So,
in addition to my total support on these proposed rules and regulation, I was going over it last night, and I don't know whether I'm just very meticulous individual, but I was looking at section 6.9G, number 3. On the second sentence, it says, all lease and license agreements shall require tenants. I was wondering whether if we were to add in at least 3 words and subtenants to have a business insurance. Again, this business insurance, is it a business insurance that would indemnify the Chamorro Trust, or should we say business liability insurance? And the Chamorro Trust should also be part of that insurance. In other words, I don't want the tenants to buy insurance, then later on terminate insurance without our knowledge. And if anything happened or failed to pay the premium, we will be also liable, because since we are the landlord. Do you follow, Senator, what I'm writing at?
yeah, I do.
Okay. And I haven't discussed this with the Mr. what do you call this, Borja, but on section 6.98, on the last sentence, it says all agreements shall be executed by CLTC, Administrative Director, Attorney General, and the Governor. Would it hurt if we put in CLTC Chairman, Administrative Director, Attorney General, and let the Chairman or the Vice Chair also be part of this document?
What line, that's page 9, line what?
The last sentence, 19.
All agreements shall be executed by CLTC Administrative Director, the Attorney General, and the Governor.
I'd like to insert the chairman of the CLTC, so we can hold him also accountable. Check and balance between the Commission and the Administrative Director. Despite that, I really trusted him, but that's
But
about
he's
it.
not going to be there forever, right?
That's right. Sorry. Thank you.
Okay, thank you very much, Mr. Saban. Those were good. Okay. Anybody else have anything? All right.
Can I make one short comment?
Sure.
Just a parting comment. There is a public law that seems to say that any decision made by any government agency that found to be a violation of an existing law shall be null and void. There should not be a decision made by any agencies to allow a violation of law. And I found that in one of the public laws that is still existing in the books. I also want to inform the senators that properties that existed below Anderson Air Force Base around the fringes of the cliff belong to the government of Guam. And I want to ask the legislature to affirm and confirm that finding, because right now Anderson Air Force Base think that they own the property, but it belongs to the government of Guam. And the other one is in reference to my first statement, is this law then retroactive to leases and sub-leases that were agreed upon and was not realized to be in violation of the law? Where what I'm saying is, are there subleases or are there leases of Chamorro Land Trust lands that exist that were being subleased without the approval of the Chamorro Land Trust?
And I believe the answer to that is, well, first of all, it's not going to be retroactive, but there's a provision, I believe it's in here, in the rules and regs, that that whatever is in place stays in place. However, if the tenant or the lessee finds that it will be beneficial to renegotiate under the new rules and regs, then they can come in and do that. Mutually beneficial. So, but it's not going to be just blanket retroactive. Okay. Mr. Bora, I have a question on, in the law itself, in section 75-106, it says, other officers not to control Chamorro homelands. The powers and duties of the governor and the department with respect to lands of the territory shall not extend to lands having the status of Chamorro homelands, except as specifically provided for in this chapter. I'm not sure if there's anything in this chapter that provides for the governor. In page 9 of the rules and regs in section 6.9H, the governor is his signature, all agreements on line 19 there, and this is where Mr. Sablon was making reference to, but it reads there, all agreements shall be executed by the CLTC Administrative Director, the Attorney General, and the Governor. Is there a conflict there?
I don't think so, because that's a function of the executive department to approve those kinds of contracts, and that's why the governor is signing it after it's been approved to form by the Attorney General. But in this specific case, because it deals with the land, then it also gets the final approval of the legislature.
But if the governor doesn't sign off on the lease,
then it doesn't get executed.
That's right. But the law says not to control Chamorro homelands. And it says specifically, the powers and duties of the governor shall not extend to lands having the status of Chamorro homelands. So it just seems kind of...
Right, but I think what we're looking at here is just because it's a function of the executive branch to execute contracts. That would be why it's included. I mean, it's something we can go back. I mean, it was reviewed by the Attorney General, and I believe that's what they saw too. And it was an extensive review on their part to determine this stuff.
Mr. Chair.
Yes, sir.
Ask the lawyer.
No, just as a comment. On that provision, that was the original law. And that was the reason the governors, before the decision on the Chamorro Land Trust, were opposed to the establishment of the Chamorro Land Trust because they did not want to lose control over these properties. And once we issued the opinion that the Chamorro Land Trust could and should be implemented, they did lose it, and it was given to the Chamorro Land Trust Commission. You remember, I think you were a member of the legislature when all the land wholesale was given to the commission, and those that the government wanted to hold in reserve were held in reserve. And those were the ones that the governor had control of. But in these now, the Chamorro Land Trust will be making the decision on the leases. The governor's signature is purely ministerial because he's already lost control of that. Prior to that, the governor could be the one that signed the leases to all those things. All the arriendos and everything else was done without anybody else but him. And that was the reason why the governors were so opposed to the implementation of this law.
So based on that, then conceivably, a lease is an agreement is formulated. The CLTC Administrative Director, the Attorney General, the chairman will, if we add in the chairman of the CLTC, they all sign off on it, approving it. The governor doesn't approve of it, he doesn't sign it. Then it still comes down to the legislature for the legislature's approval or disapproval?
I'm sure that if that happened, someone would take it to court and remind the governor that he has only ministerial power over the property, because all of this land is now under the jurisdiction and control over these very powerful commission members. I remember many of the early discussions in the 70s about why nobody wanted this to go into effect, because the loss that the governors would have over being able to be the ones that directed the use of these properties. And that was the original one. But this one now, I think, and this one is just purely ministerial because all that land is already in the Chamorro Land Trust.
Okay.
And the legislature divided the reserved land and the Chamorro Land Trust. And that's why, as you have been one of the most outspoken persons protecting anything trying to be taken out, it's you as a legislature, when you were first here, gave that land to the Chamorro Land Trust, and they're the ones now that have control over it, and they're just asking for a ministerial signature.
So we'll get back to the Legislative Council on this one here to see if we're colliding, and that maybe that collision can be just avoided by deleting that word, but we'll have to check that. See, I wouldn't have caught that if Mr. Okay, fine. Oops. All right. If there's no further questions on Bill 139-33, then we'll deem this particular bill to have been duly heard. Thank you very much, Mr. Sablan, for your input. The next bill that we will discuss will be Bill number 140. It's an act to amend Section 60112 of Chapter 60, Title 21, Guam Code annotated relative to legislative approval for agricultural land use. And just as the reason why this bill was introduced was that probably the majority of leases that are being issued are either residential or agricultural. And the bill basically then, and the common denominator between these two leases is the size of the land. I believe for subsistence agriculture, it's an acre or less, or between a half acre and an acre, and for residential leases, it's between a quarter of an acre to a half acre. And right now, the law allows for the land trust to approve leases for residential leases without having to come to the legislature for approval. And so now we want to expand that to also apply to subsistence, agriculture, and aquaculture leases. And that's to be distinguished from regular agricultural leases, which can be up to 20 acres for commercial purposes. So, Mr. Borja, if you have any testimony.
Thank you again. On Bill number 140-33, the primary purpose of this bill was to correct an omission in the Guam Code annotated, which excluded CLTC agricultural leases from the language. The original basis of this section of law derived from Public Law 30-21, which dealt primarily with the possibility of leasing land to the federal government in anticipation for the military buildup. Because the agriculture and residential leases issued by the Chamorro Land Trust are already governed by 21 GCA Chapter 75 and its associated rules and regulations, this bill was only supposed to include agriculture and aquaculture leases as being excluded from legislative approval. Specifying subsistence leases and subsistence aquaculture leases in this bill submits that the legislative approval is required for commercial leases for agriculture or aquaculture use. The Chamorro Land Trust asks that this bill allow for agricultural and aquaculture leases be exempted from needing further legislative approval since they are already administered in accordance with 21 GCA 75 and the CLTC Paul Bordalio rules and regulations. Furthermore, based on the 4 types of CLTC leases and licenses listed in 21 GCA Chapter 75, Section 75107, the CLTC also requests that grazing leases be exempted from legislative approval since it follows the guidelines established in the law and in the rules. However, should this bill only exempt subsistence agriculture and subsistence aquaculture leases from legislative approval, then we request that the size definition of these lots be changed and that aquaculture, agriculture, subsistence leases be not less than a quarter acre, no more than 5 acres, and commercial agriculture and aquaculture leases be not less than 5 acres and not more than 20 acres. And thank you for submitting this, allowing me to submit this testimony. Again, it was the whole idea here was we found this discrepancy as we were creating these rules and regs and realized that we needed to get the legislature's approval for the mainstay of our leases, which are agriculture and residential leases. Now, we very rarely give out the larger sets of leases. However, that's not to say that there are many leases already in existence that are at the 20-acre size for agricultural leases. But in the 3 years I've been on the board and in this job, we had not done those very large leases, and we had already been following what the rules and regs stipulated that said that if anyone wanted something of size, they had to come in with the farm plan, and if they wanted something much larger, they had to show us what they could do with 5 acres first before we moved them on into anything larger. And we're still at that stage where we're watching some folks as they produce on their 5 acres. There are some successful ones out there. I mean, there are even some very successful ones that are on agricultural, the subsistence sizes where they're up to 3 acres, and I've seen some very good ones. Now, that's not to say that everybody out there that has an agricultural lease is doing the job that they're supposed to be doing with agricultural leases, because there's 2 ways to use agricultural leases, and that's to farm the land actively or to plant trees. And the law specifically says how many trees they must plant over the course of, I think, 5 years. And it's quite a number of trees. But that's, trees pepper plants are not trees. I mean, some of these need to be permanent trees. And again, there are some very good examples of those out there where they're planting the trees. And there are many cases out there that there's no activity again. And that's going back to my original comments from the first bill where I stipulated we needed to be more cognizant of our enforcement and compliance in those areas. But in this case, if we're going to only ask that the subsistence agricultural leases be exempted, then we just ask that the size be increased from the maximum of half an acre to 5 acres, because half an acre for an agricultural lease is quite small.
Any questions, comments? Okay, so public hearing, Bill 140-33 is deemed to have been duly heard. The next bill is Bill 138-33, which is an act to amend Title 21 Guam Code Annotated Chapter 61, Section 61217, pertaining to federal excess land zoning to provide clarity and maintain uniformity on all zone changes. Mr. Borja?
Thank you again, Senators. On Bill number 138-33, Title 21, Chapter 61, Section 61217 was originally crafted to provide a zone designation of agricultural zone to federal excess land returned to the government of Guam because these lands were not zoned under the when they were under federal control. However, the bill had amendments added prior to its passage, and these amendments, while well-intentioned, were vague on its execution. During a recent Guam Land Use Commission meeting, a landowner asked to elevate the zoning of his property under the conditions of this of 21 GCA Section 61217. Unfortunately, the commissioners could not entertain this landowner because of the lack of clarity in the law. First, the definition of the landowner was unclear, and secondly, the land management action required for documents the landowner was instructed to provide was absent. This bill reverts the language of this law only to apply the A zone, agricultural zone, to return federal excess lands and to instruct landowners that an increase in the zone should be done using established zone change procedures. Passage of this bill will establish clarity in the law for both the landowner, the Planning Division of the Department of Land Management, and the Guam Land Use Commission. Again, it was the first time the Land Use Commission had experienced this situation in which an individual had purchased property that was originally returned to original landowners. He purchased the land from the original landowners and then was trying to change his land zoning in accordance with this section of the law. The definition of the original landowner was in question because in one part of the law it specifies original landowner, and then thereafter it starts calling them landowners. So who was it really? The one that currently owns the land, or only the people that were originally owning the land? That was why they couldn't act on it. And then it listed a whole list of activities that the landowner had to do in order to get the zone change. And these activities were actually functions that the Planning Division of Land Management usually performed in doing the zone change. So it just said, provide this activity, these documents that you've done this, and then it didn't say what you were supposed to do after that. So all we're asking again here is that the law just revert back to what it was originally designed. When that bill was first introduced, I think it was 1 or 2 sentences long. Take federal excess lands and make it agricultural A zone. And that's what we're asking it to do, and then just instructing that if they want to make any other changes, then they can go through the process of making the zone change through the processes that are already established, and they're pretty set in concrete.
Okay, and so if I may, then what the bill does is basically 2 things. One, the existing law limits limits the zone designation, the higher zone designation that is allowed, and that is
what is contiguous
with the contiguous property. So if the area is zone R2, and then now a landowner wants to rezone that property to build stores, a small strip mall, under the current law, I wouldn't be able to do that. It'll have to basically apply up to a R2. This bill removes that restriction and allows for the application for a higher zone designation by applying to land management for under the normal process. So it takes away the dual rezoning application process, a certain process for returned excess lands and the process for all other lands. So now it's just one process.
Correct.
Correct, okay.
But it still holds that any land that's returned as federal excess will be zoned agricultural upon return.
Correct, yes, okay. Does anybody have any questions about this? Bill? None? Okay, fine. So then, Bill 138-33 is deemed duly heard. And the last bill, Bill 137-33 is an act to amend the land transfer for George Tovis as authorized by Public Law 28-68 to be area for area, not to include land used by a military utility easement. And so this bill basically recognizes the fact that the property that Mr. Toves was given in exchange for his private property was actually a lot smaller because there was a easement that went right down the middle. So now he's asking that additional land be provided to compensate for that easement that runs through the property, which basically is useless to him. So, Mr. Borja, if you care to comment.
Yes, right. Back on bill number 137-33, Mr. George Tovis had a piece of property that was up along Route 3 in Ukadu High School area, and they needed that piece of property to have access to Ukadu High School. His property was a clean set of property. It had no easement on it at all. When they redrew all the lines in this property, in this area to specify where the access routes, the rights of ways are going to be, they redrew the different lots as well. And the lot that was exchanged for his had this military utility easement. Mr. Tovis has been going on with this thing for quite a long time, trying to get some understanding with the military to move the easement, number one, or to have it deleted completely. Having it deleted completely is probably not going to happen. The military wants to hold on to this easement. This easement runs parallel to the oil pipeline, the fuel pipeline. It's not co-located, it's set to the side of it, and it may be an inactive communications line easement, but it's nevertheless still required by the military. We have been somewhat successful in getting them to agree to move the easement to the edge of the lot so that at least it's not dissecting down the middle of the length of his lot. So we're asking that the area to area transfer not include the space, the amount of area that this utility easement takes up, so that it's a true area-to-area transfer, because he can't do anything at all on this easement, and that the land that's going to be taken to compensate for this will be a small section, part of the property adjacent to it, which is also Chamorro Land Trust, but it's this was an activity that occurred without the Chamorro Land Trust's input at all. And when they had asked the Chamorro Land Trust to make the approval, the Chamorro Land Trust Board did not want to act on it, since it wasn't an act that they committed in the first place. So the legislature is being asked to change, to allow the area-to-area to be, to exclude this military utility easement.
Okay, thank you. Any questions on this bill? All right. There being no questions, the public hearing for Bill 137-33 is deemed the bill is deemed duly heard. And so, if there being no questions, then the committee hereby adjourns this public hearing. The time is 3:21 p.m. Thank you.